Let's see if I have all this down. Have my notes. Hopefully, Mr. Nation, we didn't upset your trial judge today. How are you?
He is not upset at all. I am squirming a little bit just because it's, you know how it is. But
yes, sir. I had a time where a federal judge told me that I was okay to start my state court trial, that I would not be called. And in the middle of my state court trial, I got a message from the bailiff that says the federal judge wanted me to know that my trial was going to start tomorrow morning. Middle of a 2-day trial. I understand exactly how you felt.
I wasn't supposed to be trying this case this week, and here I am.
Well, I understand. Well, let me go ahead and get this done so you all can get back about your business. Mr. Labbe, I believe you get to go first. Did I pronounce that correct?
Yes, Your Honor.
How much time would you like to reserve for rebuttal?
3 minutes, Your Honor, please.
Okay, I will do my best to pick a discrete time when to interrupt you to give you that information.
No problem.
And the floor, as it is often said, is yours. You may begin.
Thank you, Your Honor. May it please the court. Andrew Labbe on behalf of Universal. So we are here today on a petition for writ of certiorari related to an order denying a motion to compel production of certain documents. Just very brief background, this is a lawsuit related to an insurance claim for water loss or sewer backup, to be more specific. The date of loss is March 1st, 2018. Claim was reported on September 9th, 2018. Now, the documents at issue have to do with, at some point prior to reporting the loss, the homeowners retained Mr. Nation's office. Mr. Nation then sent out a third party to inspect the property, document the damage, interview the insureds, and so forth. During the course of discussion—
Mr. Labbe, can you hear me?
Yes, I can, Your Honor.
Oh, great. The inspection that was done through Mr. Nation, that was at or about the time of the loss?
Yeah, it was 4 months post-loss.
Post-loss, okay.
Yeah, 4 months post-loss, 2 months prior to reporting the loss.
Okay, and after that action was taken, was the property, by the time the case is filed, has the property been remediated?
Your Honor, we don't know what the condition of the property was in July 2018. Now, there were some photographs that the trial court ordered produced.
Right.
But as far, I don't believe that there was remediation done, Your Honor, because I don't believe there was an actual overflow. I think it was a backup issue. So I'm not sure, but there's nothing in the record about whether or not there was remediation done in that.
Okay, thank you.
Yeah, no problem, Your Honor. So as I mentioned, so the trial court, the plaintiff filed a privilege log that identified photos taken on July 2nd, 2018, a report prepared on July 4th, 2018, and an invoice for services rendered dated July 6th, 2018. For the photos and the report, both attorney-client and work product privilege were asserted. For the invoice, it was just work product. The trial court ultimately conducted an in-camera inspection, ordered production of the photos, but held that the invoice and the report were protected as work product and attorney-client, and that it could not find any reason that defendant could not, without undue hardship, have need of those items in preparing their case. So I just want to briefly address the invoice first, because I think that one's the easiest. So this is identified as an invoice for services rendered. So Mr. Nation's office says, go out, conduct this inspection of the property, and then this third party invoice for their services. Under no theory of the law could that be considered work product. It was not done in anticipation of litigation. It was 2 months prior to the claim even being reported, much less, litigation being anticipated. Nor could it contain anything that could be opinion work product. It's not going to contain an attorney's mental impressions or opinions about the case. Certainly not at that time frame. And then, again, this is an invoice for services rendered by this third party.
Well, we don't know how detailed the invoice is.
Correct, Your Honor. So,
and the judge did an in-camera inspection.
Yes, Your Honor. The judge did do an in-camera inspection. I mean, I can't concede.
You know, there used to be a time when lawyers would bill for services rendered X. Those days are long past.
Right, Your Honor. So there's no contention in this case that it was an attorney who was sent out to the property. I mean, it was a third party, I believe, that Well, the trial court referred to the person as an expert. I think Mr. Nation took issue with that in his response and said it wasn't an expert, it was an investigator of some sort. But I mean, opinion work product is the mental impressions or opinions of the attorney regarding the case. It is not, you know, an investigator saying $2,000 for property inspection, $1,000 for interviewing the homeowner. In the very unlikely circumstance that it did somehow contain some mental impression or opinion of Mr. Nation, that information could be redacted, but the invoice as a whole certainly is not protected as work product. Then with regard to the report, so based on the trial judge's order, you know, he discussed that the undue hardship issue. So it appears, at least ostensibly, he found that it was fact work product. On appeal, Mr. Nation doesn't seem to be contending at all that it's fact work product. I think they actually specifically say that that is not the issue here, that the issue here is that it's opinion work product. And essentially the argument is, you know, and he filed his affidavit that said, you know, I used to do these investigations myself. Now I send out this third party and I tell them what to look for and I tell them what questions to ask, et cetera, et cetera. The issue with that, Your Honors, is that does not automatically convert the entire report to opinion work product. I mean, opinion work product is a narrowly tailored, it is protected, certainly, but it is a very narrowly tailored scope. It's the opinions, the mental impressions of the attorney regarding the case. Now, how a report prepared by this investigator, which presumably documents the condition of the property, the damage caused by the loss, you know, repair protocol, things of that nature, could contain the opinions or mental impressions of Mr. Nation regarding the case is pretty inconceivable, honestly. And again, to the extent there were some opinions or mental impressions of Mr. Nation contained in that report, then they could be redacted. But the report as a whole is certainly discoverable because what the report is documenting is the factual condition of the property at the time of the loss. You know, we have the photographs. The photographs look like any inspection that a public adjuster has ever done. You know, he uses a moisture meter. He's taking photos of water damage, of sewer backups, of pipes. I mean, it's just a simple property inspection documenting the factual condition of the property in July 2018, which we did not have the opportunity to inspect for over 2 months after that time. So the report, again, as a whole, is certainly not protected by opinion work product. It's not fact work product. I'll address that just simply because the trial court seemed to rule.
Let me ask sort of a preliminary jurisdictional question. The trial court, if it is wrong in not allowing discovery of some of these things, how have you established that this causes irreparable harm that can't be remedied on appeal? You can send out your own investigator, you can do your own inspections, you can take your own photographs, you can do whatever legwork needs to be done. And unless that is somehow thwarted, why is this irreparable harm?
Yes, Your Honor, absolutely. So, and I agree 100%. So it's not the fact we could obviously and did inspect the property after it was reported in September 2018. The issue here, Your Honor, is there's 3 distinct offenses that are being inserted in this case that the trial court's order effectively eviscerates, which this court, including yourself and Judge Casanueva, have participated in opinions holding that certiorari relief is appropriate in those circumstances. So one of the bases for a denial of the claim and what we're asserting as affirmative defense is that they failed to produce documents which were requested, which is a post-loss duty under the policy. So we said, give us these documents that you have. They did not produce anything. So we need to be able to know what they had at that time, because it's not enough. Obviously, we can say we asked for these documents on November 28, 2018, and they didn't produce them. But that's not enough for us to effectively establish that defense. We have to be able to say, we asked for these documents, they didn't produce them, and they had this report in their possession at the time. They had this invoice in their possession at the time. They had these photographs in their possession at the time. We aren't able to effectively pursue that defense without having the actual document. So it doesn't. Is
in asserting that defense, is it simply enough that they didn't provide documents, or do you have to be prejudiced? Does the insurance company have to be prejudiced in some way by the failure to provide those documents?
Your Honor, I believe there would be an element of prejudice
Okay,
involved.
so let's talk about that. In order for there to be irreparable harm, what does this record establish prejudice? I mean, you've done your own inspection, you've taken your own photographs. So where is the prejudice? And you know, we obviously don't have a complete record. There might be things that come out at trial that will establish prejudice, but for purposes of a departure from the essential requirements of law that can't be cured, what does this record show us?
So, Your Honor, I don't believe that we need to establish that the record shows that we were prejudiced by this failure to comply. We cannot adequately prove that we were prejudiced without knowing what they had. Again, I don't think, so if we ask for a document and the insured doesn't have it and doesn't produce it, you know, I'm not sure that that's a violation in the first instance, but it obviously doesn't prejudice us that they did not provide a document that they didn't have. But if they have a report, we requested the report and they didn't provide it, we need to know, and that's exactly why, Your Honor, that it establishes irreparable harm, because how can we establish that we're prejudiced without knowing what information is contained in the report?
Well, if you show at trial that they undertook remediation steps and you were precluded from conducting an effective evaluation of the claim, certainly that would be a component of prejudice. But simply getting their report at this stage, I understand the insurance company is unhappy about it, but I'm not sure that it reaches to the, anyway, we can dance round and round on that issue. And obviously I understand the argument, but I am a little bit concerned that the jurisdictional threshold may not have been met on some of these things. Same thing with the amount that they've paid to the party or company that went out to inspect. I'm not quite sure how that eviscerates, and that's really what the cases talk about, isn't it? That your defense was eviscerated, and I'm not quite sure how that's been eviscerated under these circumstances.
So just 2 points, and I want to start with the report, Your Honor. So again, as Your Honor pointed out, we need to be able to establish A, that they failed to comply, so that they had this document and they didn't produce it, and B, that we were prejudiced by their failure to produce it. There is no way we can effectively demonstrate that we were prejudiced, because the report could be 10 blank pages, right? And obviously we would not be prejudiced by that, or it could contain material claim related information that we were not provided that would help us establish prejudice, but we won't know until we get the actual report. So there's no way for us to effectively establish the prejudice prong without knowing what information is contained within the report. With respect, and I also do want to point out, there's also another defense. We have asserted the concealment or fraud, saying that they intentionally concealed material facts related to the claim prior to filing suit. And again, in order to effectively demonstrate that, we need to be able to establish what information they had during the claim investigation that they did not provide to Universal. And in order to do that, we need to know what information is contained within this report. So I do think that, again, for both of those, for the failure to produce and for the concealment or fraud, it does effectively eviscerate the defense, because there's no, I mean, sure, we can assert it, but we can't effectively assert it without knowing the contents of the actual report. With regard to the invoice, I would agree that the amount paid, but at this point would not be irreparable harm. But at this point, they have not even disclosed the identity of the investigator. I mean, this is a fact witness who has factual information regarding the condition of the property prior to it being reported, presumably other information related to the claim. We are entitled to conduct discovery on this individual. So we don't know his identity. So that would be the irreparable harm from the invoice, because, you know, again, what this court has held is that when there's a discovery order, the discovery request is reasonably calculated to lead to the discovery of admissible evidence. There would be no practical way to determine after judgment how the requested discovery would have affected the outcome of the proceeding.
If Mr. Nation's law firm has an internal investigator and they send the internal investigator out to gather information for him to evaluate the case, are you saying that that internal investigator would also be subject to discovery and the information he provides would be subject to discovery?
But potentially, Your Honor, yes.
Okay, I just want to make sure I understand how far you're going with this.
Yeah, potentially, Your Honor. I think that obviously leans a little bit more towards work product attorney client. But what we have here is this unknown third party who sent out 2 months before a claim is even reported. So it has nothing to do with litigation. It's not in anticipation of litigation. There's not even a likelihood of litigation at that point. Who's documenting the physical condition of the property? Now, of course, so let's say,
But as I understand Mr. Nation's affidavit, I mean, the investigation is necessary to evaluate and provide proper legal advice and to pursue a claim. I have trouble understanding that's not any anticipation of litigation.
well, Your Honor, the case law is very clear that, you know, for work product, which again, he's not asserted fact work product, he's only saying that it's his mental impressions and opinions about the case. But mere likelihood of litigation is not enough to trigger the work product application. That comes from several cases, Neighborhood Health Partnership versus Merkel out of the 4th DCA. But basically what he said is, I told this guy, you know, how to inspect the property. Now, taking that at face value, just a couple of points. One, if he said, all right, this is a water loss claim, go out and photograph the water damage to the property. Does the fact that the wall in the bathroom had water damage, does that then become Mr. Nation's opinions or mental impressions about the case? No, that's a fact. That is a factual condition of the property at the time the loss occurred. If he says the water loss generated from a pipe behind the toilet because Mr. Nation told him to look at the toilet, does that become Mr. Nation's opinion or mental impression about the case? No, that is a fact about the condition of the property, and so on and so on and so on. Now, the Florida Supreme Court did address a pretty similar issue in the Southern Bell Telephone versus Decent case in 1994. And essentially what happened there is there was this internal investigation that was directed by the company's attorney. And as a result of that investigation, a report with recommendations was prepared. And the company said, no, you can't get the report. That's opinion work product because our attorney, it was done based on the direction of our attorney with his, you know, impressions, his opinions. And the court said the fact that the panel recommendations were based on work product does not convert the report itself into work product. And it ordered the production with the redaction of any counsel's notes, thoughts, or impressions. And then they went on to say that we reiterate that the information recited to the managers by Southern Bell's counsel is not to be redacted. So the fact that Mr. Nation may have said, go out, look at the walls, go out, ask this question, go out, do that. That does not convert the entire report into work product. To the extent somehow Mr. Nation's opinions or notes or impressions of the case made their way in there, those can certainly be redacted, but the report as a whole is discoverable. And again, even with the communications, so that was another contention that the report contained some statements by the insureds that were based on questions Mr. Nation told this investigator to ask them. And the court considered a similar claim there and said the communication between the attorney and client is privileged, but the underlying facts are discoverable. So we are still entitled to know the underlying facts of the claim. We're still entitled to know the factual condition of the property notated and outlined in the report. That is not opinion work product just because Mr. Nation may have said, do this or do that when he goes out there.
I should tell you that you have just hit 17.
Okay. Just very briefly, I just want to just to the extent, and again, I feel very strongly that there is that the report as a whole cannot be protected as work product or attorney-client privilege. But to the extent such privilege did exist, we would argue that that privilege was waived in this case, because in their complaint, they specifically say we complied with all conditions precedent under the policy. So they're saying we complied with our duty to provide documents that you requested. Right? They can't on the one hand say that and then on the next hand say, but we're not going to tell you, we're not going to show you what documents that we actually had in our possession that you asked for that we did not produce. So there has been waiver found in the Florida Supreme Court. Savino versus Luciano is the big case out of from 1957. So the trial court did depart from the essential requirements of the law in finding that the report and the invoice in total are privileged and not discoverable in this case. And it would cause irreparable harm that cannot be remedied on appeal because it effectively eviscerates our defenses of their failure to comply with post-loss duties and their violation of the concealment or fraud. And there would just be no practical way to determine how the discovery would have affected the judgment post-trial. Thank you, Your Honors.
Shall I proceed?
Just a second, Mr. Nation. I am the designated timekeeper, and I have to adjust the clock unless you want to start with 18 plus minutes already gone. That's all I was doing. So I thank you both for your patience, and we are ready to proceed.
All right, thank you. And thank you, counsel. I want to make sure we're clear about what happened at the outset when I was retained. I was retained and asked to look into this to determine if there is a valid claim. To do that, I did three things. I sent out this company who I have retained and said, go interview my client. I used to do that. The affidavit sets forth that. Interview the client, hear the questions, and document the answers so that the question and answers are in this report. And take very specific photographs. Here are the photographs of the areas that I would like you to take. When I get that back, I review it, or one of my attorneys does. Go through it with the client, go through the policy, and determine, is there a potential claim there? People are reluctant often to file claims because they know the impact that may have on them. If the answer is yes, I want to proceed and the client wants to proceed, I hire a general contractor and a plumber as a consulting expert to go evaluate the house. And that happened here, and evaluate the systems. They generate photographs and reports. In this case, that's exactly what happened. And those photographs and reports from the general contractor and the plumber, my consulting experts, I decided to waive those and provided them to Universal. As to the interview of my client, we did not give them that, nor are we required to. If I interviewed the client and asked those same questions and answers, they wouldn't be entitled to it. If I sent my legal assistant out to do it or investigator, they wouldn't be entitled to it. Here I have an independent third party who's acting as my alter ego, asking very specific questions and documenting the answers in that report and photographs. Judge Yancey decided, after reviewing it, the report and the photographs, and said, give them the photographs. We did the next day. They have the photographs. The facts are the facts. They can go and they can look at those photographs and determine those facts. They can call my client in for a depot and ask about those photographs. And was that the condition on that day? They have their own inspection. They have a couple hundred other photographs taken by my general contractor and plumber. Now, Judge Yancey did exactly what he is supposed to do. He had an in-camera inspection. He reviewed the report, looked at it, said, all right, give him the photographs. The remainder of it is protected. It's protected by the attorney-client privilege. And he just put work product, and then he talked about need and seemed to be discussing a test that deals with fact work product. But I filed supplemental authority in this case last week, which was an order on summary judgment, because Universal continued pushing this and saying, since we didn't give them items that are deemed protected by the attorney-client privilege and work product, that they were entitled to summary judgment. And Judge Yancey went through there and on page and entered an order against them, saying they're not entitled to those materials. He's reviewed them. And he has a whole section on it, page 8 of his summary judgment order, saying that the doctrine that he applied is the opinion work product doctrine in determining that those materials were not discoverable. And Southern Bell versus Deason makes that crystal clear, that if it is opinion work product, it's not discoverable. But more importantly, in this case, that is attorney-client privilege, and he's determined that. He has looked at that. They cannot show an error, let alone a departure from the essential requirements of the law, and they certainly can't meet this jurisdictional limit showing a manifest injury. They have the pictures when they were taken. They can have their expert look at those pictures. What do they want to do? Go interview? It'd be the same as interviewing me and saying, all right, what did you think about these pictures? Why'd you take these pictures? What do they show you? What do you think they show? They've got the pictures. They can't have my alter ego and say, and what did the client tell you? Because that's what this report has in it. And they're not going to be a testifying expert or anything like that in this case. They simply went and got the information that I needed to be able to sit with my client and go, all right, do you have a claim or not? Yes. All right, let's get the GC and plumber out and see if there's any information they can give us. We gave them all that. They have everything they need. They do not get my attorney-client privilege. And what they're really saying is, we don't know what the client said to Mr. Nation's alter ego, and we really want to know, and we want to get that. Well, they don't get it as much as they want it. The fact they want it so bad is pretty good evidence of why it's protected as attorney-client privilege. I don't think I have anything else unless there are any questions.
Here's, I don't see any questions coming. Thank you, Mr. Nation.
Thank you.
And we will return to the petitioner here as I turn off the clock. And you have 2 minutes remaining, counsel.
Yes, Your Honor. So it's kind of a moving target here with what the arguments are, because in their response, basically the attorney-client privileges kind of brush aside and says, you know, it includes some statements from the clients made to the investigator. So, but the focus is, well, this is opinion work product because I told him how to conduct this inspection. I told him how to conduct this investigation. If there are confidential communications within that report that meet the standard for attorney-client privilege, those can be redacted. If there are any notes or opinions or mental impressions of Mr. Nation, those can be redacted. The report as a whole is discoverable. The report is documented. I mean, the photographs make clear, and I don't think Mr. Nation made any assertion that that investigator is not going out there and documenting the condition of the property and the facts related to the claim in July 2018. Those are facts. Those are discoverable in a case. They are not converted. And again, the Deason case makes absolutely clear, and that's the main case that Mr. Nation is relying on. It makes absolutely clear the report as a whole is not privileged by opinion work product, that you can just redact anything that meets the definition of opinion work product, which is not what was done in this case. I'd also point out, again, to the extent that the trial court finds there is confidential communications, those can be redacted. But in the Deason case, almost identical claim was made. So the Southern Bell claimed that counsel directed, controlled, and was sometimes present at the employee interviews. And the court said that does not invoke the attorney-client privilege. Because the issue here concerns the employee statements to security personnel and not to the attorney, we hold that the attorney-client privilege does not apply. So simply because he said, Mr. Nation says, go out and ask when the loss occurred. So the insured statement of when the loss occurred is not a confidential communication. It does not automatically convert to attorney-client privilege because he said, ask when it occurred. But again, the bigger issue here is that we're talking about a report as a whole, which again, based on everything in their response, contains a lot more than statements from the homeowners. So to the extent any of that meets the attorney-client privilege, it can simply be redacted. But it clearly deals with the factual condition of the property, the facts of the loss and things of that nature, which do not meet any articulated privilege under Florida law. And again,
I think your time has expired, as they say.
that's fine. Thank you, Your Honor.
I thank you both and hope everyone stays well. And that will conclude our oral argument for session for today. Thank you all again.
Thank you all.
Your Honor.